to discuss the Nkabinde panel's findings clearing Advocate Chauke of the allegations leveled by former NPA head Advocate Shamila Batohi. We are joined now by independent legal analyst, good friend of mine, Bophelo Sileke. Good evening to you. Thank you for your time this evening and prompt response to our invitation. So, could you have scripted this at the start of the inquiry? I remember the allegations as they were stated, as they stood before they were tested through the process. I don't know if many people would have scripted it, the outcome of this nature.
I couldn't have. And perhaps the most dramatic aspect of the inquiry involves the former NDPP's testimony herself, where she testified, or at least she tried to testify extensively against Chauke. And what we need to remember is, among other things that she would have alleged prosecutorial overreach, political motivated decisions that were taking place within the office of the DPP, being Andrew Chauke. She further alleged that there was a failure to prosecute where evidence allegedly existed, and there were improper prosecutions in numerous matters. However, Tulas, the inquiry became controversial, as you and I would have learned as we kept a peeled eye of the proceedings, when Batohi declined to continue with cross-examination, and she further made a request to the commission to provide written evidence instead. And of course, we now know how that went. I mean, Justice Nkabinde refused, and the reason why she would have refused is because procedural fairness demands that witnesses be tested under cross-examination, and that principle that comes directly from our constitutional understanding of fairness. It's a Section 34 right, which guarantees fair public processes. So cross-examination remains one of the strongest safeguards against what can be termed as unreliable evidence.
Many who have picked up on this inquiry along the line would be wondering how it went from a question that says, is Advocate Andrew Chauke fit to hold office as DPP in South Gauteng, and ended up being an inquiry into the goings-on and how the whole matter of the Kato Mana police unit was handled. Does the answer to that lie somewhat, in some respects, Bophelo, in this whole charge around racketeering and the need to certify that charge before prosecution can proceed on it?
Well, we can, one, locate that specific answer to the following order of events. One, it would be the former NDPP who wrote a letter to the president asking the president to look into the fitness to hold office of Advocate Andrew Chauke. And part of what she would have written in the letter as a request to the president would be quite spot on. Among other things, the racketeering and the Kato Mana issues that had been heard in another court, and a decision had come out of that court, effectively speaking to an exoneration of Boysen and the co-accused at the time. But the second aspect would be, we need to look at what the terms of reference of the commission was. And that's how we understand what it is that the commission needed to do in as far as it's looking into the fitness to hold office of Andrew Chauke. So the commission was required to establish or determine whether allegations that were placed at the feet of Andrew Chauke were indeed substantiated, whether Andrew Chauke committed misconduct, whether he remained fit and proper, that qualifier is there, whether sufficient grounds existed to recommend a removal, and notice that what the commission was not asked to us. It was not asked whether the allegations sounded serious. It was asked whether they could be proved, or the distinction in terms of what applicable law was. We now know it was established in terms of the NPA Act. But I think the veracity of what then came out of this inquiry was simple. A failure to hold under intense scrutiny, as expected, an NDPP who made severe allegations, career-limiting allegations, against a public servant or perhaps a seasoned member of the NPA. And when tested on those allegations, she simply came crumbling.
Right. I want to ask you, Bophelo, because there are many other allegations that we've gotten an answer to in the outcome of this, including the allegations around the Richard Mdluli matter being one of those examples. We don't have time to get into that, and that's because I think that the allegations to do with the Kato Mana situation, I suspect that story still has some legs to it and may well run. And part of that, and relying on the reporting of our colleague and friend, Karen Mon on News 24, reporting based on the letter itself from President Ramaphosa to Advocate Chauke, and I quote here, evidence existed, well, the Nkabinde panel found, however, that, quote, evidence existed which supported the institution of such charges against Major General Boyson and members of the Kato Mana unit, end quote. Your thoughts about the implications about this issue of the Kato Mana unit as a question of public interest this evening?
I think there was a reignition, of this specific gray area of our public record or our public history. And it came out during the commission where explosive testimony, of course, and ballistics evidence were introduced alleging a blueprint of systematic killings in as far as this unit was concerned, where officers, and one of the allegations was that the officers were rewarded for shootings and firearms were planted at certain crime scenes to justify the deadly force that might have been used. But I also think we need to remember, the long memory that we need to commit to is, you'll remember that former officers would have initiated civil damages or civil claims against the state for years of malicious prosecution. So in examining what would have been the view on how the Kato Mana and racketeering charges would have been handled, and perhaps whether they still have a leg to stand on in future, we also need to remember what was also unfolding on the sidelines, on the periphery, that may have not been reported on. So holistically looking at what came out with specific reference to this, Thulas, we need to remember the following. One, it was the responsibility of this commission to establish the veracity, or at least the truthfulness of the allegations that were put. Failure to do so, Advocate Andrew Chauke cannot then still be under a cloud of some nature or of some sort, having subjected himself, and I think the president acknowledges it, that he thanks him for subjecting himself to this process until its conclusion. And that's how we need to look at it, that when it really came down to it, Advocate Andrew Chauke sat and presented himself to be subjected to this process, which was the fact-finding process. And when it really came to it, it did not pronounce anything with regard to whether he ought to have done anything differently, or in the instance that he did, that what he did was unlawful, or it became less of what is expected of a person holding the office of a DPP.
All right, Bophelo, thank you for that. I've got a feeling we'll be talking about this. I certainly got the sense that as the inquiry unfolded, I said, hang on, should we be inquiring into this question rather? The question around what happened with the Kato Mana police unit. Independent legal analyst Bophelo Silike there, weighing in on what has come out, the stunning news that has come out, the Nkabinde Inquiry clearing the South Gauteng DPP Advocate Andrew Chauke.